Hello everyone, welcome back to Patenevo. Before we start, I want to set your expectations correctly here that this is not going to be a class where I would be reading out sections of the Trademark Act to you because you already know these sections, and today I am going to show you how a real cease and desist notice is actually built from close to close. And by the end of the session, you will be able to draft a complete court ready cease and desist notice for your trademark infringement matters. And you will have seen this exact same structure in a notice which is actually filed by the top tier firm. So let's start by a question in mind that why a cease and desist notice is even sent. So there are basically three reasons, and I want you to remember these reasons. The number one, that it's a pre-litigation remedy. It gives infringer a real chance to stop without either party incurring the cost and uncertainty of the full suit. Number two, that it creates a documented evidence trail, and this notice may well become an exhibit in a suit you may file 6 months from now. Number three, that it signals a good faith to the court. So basically, the judges view a plaintiff who attempted resolution first far more favorably than the one who rushes to sue. So remember that the notice you draft today is not just a warning, it is the first page of a court file that may not even exist today. So here is the single most important slide of today's class. Write this down that every cease and desist notice follows the same 8-part skeleton, having a header and mode of service, having a client identification that gives the subject line, the credibility paragraph, and they also narrates the grievances and the cause of action, then operative demand and the consequences clause along with the closing. So once you know the skeleton, that you can after that you can draft a cease and desist notice for any cause of action. Only the content inside each box would be changing. So today we will be building it twice, that one from scratch on a fictional case, and then I will show you exactly the same skeleton inside a real notice actually sent by a law firm. So let me introduce today's fact pattern. It's a fictional matter which was built to teach today's structure. In this, you can see that our client is Sundrop Beverages Private Limited, which is a registered proprietor of the word mark Sonora, which is SUNORA, and they registered it in class 32. You must have read about the NIST classification. So the class 32 gives about the fruit juices and the beverages. Uh, the registration number, I have made this registration number as 3456789, and this was registered on 12th March 2018. Remember the date of registration here, and also remember that this mark was used continuously since 2017. Here you can see that the infringer is Miss Sonora Foods. They have used uh, the same word mark with the change in a spelling as an extra O, which is SUNOORA. They are sending the packaged fruit juice under the same mark Sonora, which was discovered on the date 14th July at a retail outlet in CP Delhi. Notice that near identical phonetics were used, and they have identical class of goods, which is class 32, and a similar orange and white packaging was used here. with the same trade channel as New Delhi NCR. So every element you need for a strong notice is sitting right here. So let's start building it. Part one we have talked about is header and client's identification. So make sure that you always send a notice through two modes, which could be email for speed and registered post for a legal proof of delivery. This closes off any argument that a recipient had never received it. Uh, in part two, you can see that the client identification for our matter, the Sundrop Beverages Private Limited, which is a registered proprietor of Sonora. As we have already seen, the registered registration number we have 3456789, and it was registered in class 32. And I told you to remember the registration date. So it was registered since 12th March 2018. Okay. So miss any of these four details, that a full legal name, the registration number, the class, the date, the nature of business. If you miss, then your notice would look like an empty threat with just no rights behind it. Okay. So now we come to the part five, the factual narrative uh, or the grievances part. This is the longest and I would argue the most important section of the whole notice, because this is where most students go wrong. They write vague and emotional language instead of the specific and provable facts. Okay, so look at this comparison table, that this is exactly how you should be thinking when you draft this section. The same mark phonetically, the same class 32 for fruit juices, and a similar sound, similar packaging of orange and white, citrus, and the same trade channel as Delhi NCR supermarkets. So in the actual notice, I drafted this as four lettered subpoints. And I want you to understand that why I do this instead of writing one long paragraph. Because if I write one giant paragraph and one part of my argument is weak, I can drag down the whole paragraph's credibility. Okay. But if I break it into a separate lettered points, then each one is independently provable and independently defensible. Okay. If the opposing counsel attacks one point, my other 3 points would be standing still on their own. Okay. And this is a drafting technique. Okay. Not just formatting. You use it every time you are building a multi-ground argument. So part six of our skeleton, the cause of action. This is where you tell the reader and eventually the judge that exactly what law supports your client's position. You never assume it's obvious, so you have to state it. For a trademark matter, you are pleading two things together. Okay. First is statutory infringement under the Section 29 of Trademark Act. Section 29(1) covers the use of an identical or deceptively similar mark on identical goods, and Section 29(2) covers the likelihood of confusion arising from similarity of the mark and the goods. Okay. The second, and don't skip this even if you have a registration. Okay. You plead passing off as well. Because remember, the classical Trinity case from Recite and Coleman case, that they have given the classical Trinity of goodwill, misrepresentation, and damages. Goodwill, that our client has built a real reputation in Sonora mark, and misrepresentation, that the infringers use uh, is a deceptively similar and which is likely to causing the confusion. Okay. And in damages, that our client is losing the sale and the distinctiveness of its market, and the distinctiveness of its mark is being diluted. Why we plead both these together? Because passing off protects you even in a situation where a pure infringement argument might have gaps. For example, The dispute over classification or use outside the exact registered class. So you always plead the both. Okay. Now part 7, and I tell everyone that this is the single most important sentence in the entire notice, the operative demand. Uh, Look at this weak version on the left, that please stop this immediately. So a judge reading this cannot test the compliance against it. Stop what exactly? And you have to tell this, that what to stop and by when, because it sounds like an angry letter, not just a legal instrument. If you say that please stop this immediately. Okay. So now look at the stronger version on the right, that you say that cease and deceit from manufacturing, selling, offering for sale, advertising, or dealing in any goods bearing the mark Sonora, or any mark deceptively similar to our client's registered mark Sonora. The registration number, you mention it, okay, along with the class and a specific time period, that within 15 days of receipt of this notice. Okay. So notice three things about the sentence: that this sentence is specific, it names the exact mark and the registration it is based on, and it is time bound, that 15 days, not immediately, because it is vague, and the 15 days timeline is actionable. Okay. So the recipient can read this and know exactly what compliance look like. Okay. So this is the sentence a judge will read first if this matter ever reaches the court. Okay. So draft is like your case depends on it, because it might depend on the operative demand. Okay. Now part 8, the consequences clause and the closing. So so two things here. First, the consequences clause tells the recipient that what happen if they don't comply, because you are reserving the right to initiate civil and wherever applicable the criminal proceedings. Okay. So including a suit for criminal proceedings, including a suit for permanent injunction and retention of accounts. Second, I want every one of you to properly understand this phrase, because I see it, it is misused constantly by the students, that without prejudice. Okay. So this phrase means that this notice does not limit or waive any of the client's other legal right or remedies. Okay. You're not settling anything by sending this notice. You are reserving everything. Okay. So here, why this matters practically, because you sent a notice without this phrase, and a clever opposing counsel can later argue that you limited your own client's remedies to only what was stated in the notice. So remember that you never send a cease and desist notice without this reservation, because it costs you nothing to include, and it protects your client's full range of remedies later. Okay. So So now here is where I want you to see everything that we have discussed uh, actually sitting on paper. And this is the complete formatted cease and desist notice for our Sonora matter. And it is drafted the way it would genuinely go out under a firm's letterhead. And at the letterhead, you can see the Chandra and Rao Advocates and Solicitor Intellectual Property Practice. It is a professional letterhead, because the presentation also matters, and this is going to a business owner and possibly to a judge. Okay. So on the top right side you can see that by speed post, registered AD, and email. Remember the part 1 exactly, what we discussed, the two modes of service, and they are stated right at the top, so there is no ambiguity later about how this was sent. Okay. So now it is addressed to Sonora Foods, whose proprietor is Mr. Rakesh Malhotra, having full shop address in Karol Bagh. Okay. Why? Because you need to be certain that you are serving the right party. Okay. Now, here is part two. Our client, the Sundro Beverages Private Limited, having the registered office at and acting through its authorized signatory, including its director and management. Okay, so full legal name, the registered office, and notice how it extends the coverage to the directors and the management too, because anticipating that the dispute could touch individuals and not just the company. Okay. In the part three, the subject cease and desist notice, infringement of registered trademark Sonora, and uh, passing off. So notice one thing here that this subject line name both cause of action in the subject line. Okay, so the reader must know exactly that what is coming before they have even read a single paragraph. They get an idea that it is a notice about infringement of registered trademark. This. Okay. Now, part four, the credibility paragraph. So, before any allegation, we establish here that who our client is, the Sundro Beverage Private Limited, and they are manufacturing and selling since 2017. Okay, and they sustained investment in advertising. They have substantial goodwill built through the consistent quality. Okay, only after this, the paragraph 2 comes in. Okay, where we gives the details about registration number, that the registration number is this and the word mark is SUNORA. Okay, and it was registered in class 32, which is non-alcoholic beverages and fruit juices, fruit drinks. Okay, and this was registered on 12th March 2018, and the mark was used since March 2017. So this is our proof of prior right stated with complete precision. Okay, now paragraph 3 and 4. Okay, this is part 5. Okay, paragraph 3 and 4 gives the part 5 that we discussed about the grievances. And I want you to exactly know that, exactly see that how it is constructed on the page. Okay. In the paragraph 3, it has recently come to our clients notice that you are manufacturing, marketing, and selling fruit juices under the mark Sonora, SUNOORA, which is discovered at a retailed outlet in Connaught Place, Delhi, on dated 14th July 2026, and photograph of which are annexed at Annexer B. Okay, so here you notice the specificity that a date, a location, and it is also backed by an annexer reference. Okay, because you never alleged discovery without saying when, where, and what evidence support it. So you must give evidences of photographs as annexer B. Now, Uh, in paragraph 4, you can see that here is the lettered structure I told you about now actually on the paper, that subpoint 1, the phenotypically and visually similar. Okay, subpoint 2 as identical class of goods, and subpoint 3 as trade dress and packaging, and subpoint D with same trade channels. So, four separate and independently provable grounds, each one with a complete argument on its own. So this is exactly the technique that you don't bury four arguments inside one paragraph. So because you let each one stand alone on the page. Okay. Now in paragraph 5, you can see the part 6, the cause of action, which is written exactly as we discussed. The infringement under section 29(1) and 29(2) of the Trademark Act 1999, and passing off with three elements spelled out as misrepresentation, confusion, and damage to the goodwills. Okay. Then paragraph 6 state the harm, the irreparable loss, dilution of the mark, and the loss of sales. So this is the injury paragraph that justify the injury. Okay. S- Now in paragraph 7, the operative demand is given, and look how it is structured, that we hereby call upon you within 15 days to and then five separate number demands as cease and desist from specific conduct, withdraw any pending trademark application, or destroy or hand over existing stock and packaging, and furnish a return undertaking with a disclosed sale quantum, and in the last, tender an unconditional return apology. So I want you to notice something here that we have not discussed yet, that this notice does not ask for just one thing. It asks for five specific and distinctive remedial actions. Okay, because each one is independently actionable, and that is a stronger notice that than one just say that stop using the trademark, because it gives the recipient a complete checklist of exactly what compliance looks like. Okay, so finally, paragraph 8, that this notice is issued without prejudice to our client's right to claim damages, retention of accounts and profits. So there is our phrase again, that doing exactly the job which we had discussed, that you are reserving every single remedy, and immediately after, in the event of your failure to comply, the civil and criminal proceeding before the High Court or any other such court of competent jurisdiction, entirely at a risk or cost and consequences. Okay. Now coming to paragraph 9, that a copy of this notice is retained in our office records for future references and use. This one line, but it tells you everything about how a firm thinks. Okay, this notice is being filed uh, away as a future court exhibit from the moment it is signed. Okay, now coming to the closing block, that it is signed for Chandra and Rao advocates by the partner with a CC to the client for their own record and annexures listed, and the registration certificate and the photographs which are referenced earlier in this notice. So every reference made earlier in the letter is backed by an actual attached document, because this is not a decoration. Okay, this practice is what makes this notice credible enough to survive any scrutiny if we are placing this ever before a judge. Okay, so there it is, the complete 8 paragraph skeleton built from scratch in front of you, and now sitting exactly where it belongs on a fully formatted professional legal notice. So before we do our drafting exercise, let's look at 5 mistakes I see that most often when I review junior drafts. Okay. The one is that you make a vague demand with no timeline. Okay. Another one is that you miss the prejudice part. Okay. And another one is that you aggressively tone with no stated legal basis, and there is no proof of the client's prior right before alleging the infringement, and you are treating it as one off letter that um, you are not going to exhibit in the court further. Okay, now it's your turn. Okay, pause here if you are watching the recording and take your time. Okay, here you can see that our client is Miraki Foods Private Limited, having the registered mark with Miraki with single I in the end, and they are registered in class 30 of snacks, and they are registered since 2019. And the infringer is a new snack brand Miraki with double I in the end. and they have same retail category, similar packaging color scheme. Okay, so you need to draft three things here. One is the client identification paragraph, then the grievance paragraph, and spend the most time here, the operative demand sentence. And then the test is that is it specific, time bound, or actionable. Okay, so let's recap. Every sentence in a cease and desist notice does one of the three things: that it establishes a right, and it states a fact, or it makes a demand. Okay, the eight part skeleton for any cause of action, and now you have seen it. We seen it. We have built live and seen it sitting on a fully formatted professional document. Okay, so the operative demand is the most important sentence, which is specific, which is time bound, which is actionable. So you always reserve right with, without prejudice, and draft every notice as if the judge is reading it. Okay, because one day they will be, right? Now that brings us to the end of today's session. You have built a cease and desist notice from scratch and seen it coming together as a complete professional document section by section. So before our next session, practice the skeleton on 3 to 4 fact patterns of your own. And if you would like more of this practical document first teaching, not just theory, follow our pages and visit our website patenevo.in. Thank you, and I will see you in the next session.